I have a dream, that's all I need. I'll make it happen with some work and belief. Know what I want, so I'll take it on. I'll make mistakes, but mistakes make you strong. Let's break it down for a minute.
Section 86. For purposes of this code and subject to its provision on dissolution, a non-stock corporation is one where no part of its income is distributable as dividends to its member, trustees, or officers, provided that any profits which a non-stock corporation may obtain incidental to its operations shall, whenever necessary or proper, be used for furtherance of the purpose or purposes of which the corporation was organized, subject to the provisions of this title. The provisions governing stock corporation when pertinent shall applicable to non-stock corporations except as may be covered by specific provisions of this title. Section 87. Non-stock corporation may be formed or organized for charitable, religious, educational, professional, cultural, fraternal, literacy, scientific, social, civic service, or similar purposes like trade, industry, cultural, and like chambers or any combination thereof, subject of the special provision of this title governing particular classes of non-stock corporations. Section 88. Right to vote. The right of the member of any class or classes to vote may be limited, broadened, or denied to the extent of specific in the Articles of Incorporation or the bylaws, unless so limited, broadened, or of denied each member regardless of class shall be entitled to one vote, unless otherwise provided in the Articles of Incorporation or the bylaws. A member may vote by proxy in accordance with the provision of this code. The bylaws may likewise authorize voting through remote communications or and in absentia. Article 89. Non-transferability of membership. Membership in a non-stock corporation and all rights arising therefrom are personal and non-transferable, unless the article of incorporation or the bylaws otherwise provide. Section 90. Termination of membership. Membership shall be terminated in the manner and for the causes provided in the Articles of Incorporation or the bylaws. Termination of membership shall extinguish all rights of members in the corporation or in its property, unless otherwise provided in the Articles of Incorporation or the bylaws. Chapter 2. Trustees and Officers. Section 91. Election and Term of Trustees. The number of trustees shall be fixed in the Article of Incorporation or bylaws which may or may not be more than 15. They shall be office for not more than 3 years until the successor are elected and qualified. Trustees elected to fill vacancies occurring before the expiration of a particular term shall hold office only the unexpired period, except with respect to independent trustees of non-stock corporations vested with public interest. Only a member of corporation shall be elected as trustee, unless otherwise provided in Article of Incorporation or the bylaws. The members may directly elect officers of a non-stock corporation. Section 92. List of member and proxies. Place of meetings. The corporation shall at all times keep a list of its member and their proxies in the form of commission may require. The list shall be updated to reflect the member and proxies of record 20 days prior to any scheduled election. The bylaws may provide that the member of non-stock corporation may hold their regular or special meeting at any place, even outside the place where the principal office of the corporation is located, provided that proper notice is sent to all members indicating the date, time, place of the meeting, provided further that the place of meeting shall be within Philippine territory. Chapter 3, Distribution of Assets in Non-Stock Corporation. Section 93, Rules of Distribution. The assets of a non-stock corporation undergoing the process of dissolution for reasons other than those set forth in Section 139 of this code shall be applied and distributed as follows. A. All liabilities and obligations of the corporation shall be paid, satisfied, and discharged, or adequate provision shall be made therefore. Assets held by the corporation upon a condition inquiring return, transfer, or conveyance, and which condition occurs by reason of the dissolution, shall be returned, transferred, or conveyed in accordance with such requirements. C. Assets received and held by the corporation subject to limits permitting their use only for charitable, religious, benevolent, educational, or similar purposes, but not held upon a condition requiring return, transfer, or conveyance by reason of the dissolution shall be transferred or conveyed to one or more corporations, societies, or organizations engaged in activities in the Philippines substantially similar to those of the dissolving corporation according to a plan of distribution adopted pursuant to this chapter. The A. Assets other than those mentioned in the preceding paragraphs, if any, shall be distributed in accordance with the provision of the Articles of Incorporation or the bylaws, to the extent that the Articles of Incorporation or the bylaws determine the distributive rights of members or any class or classes of members or provide for distribution, and in any other case asset may be distributed to such person, societies, organization, or corporations wherever or not organized for profit as may specified in plan of distribution adopted pursuant to this chapter. Section 94, Plan of Distribution of Assets. A plan providing for the distribution of assets consistent with the provision of this title may be adopted by a non-stock corporation in the process of dissolution in the following manner. The Board of Trustees shall by majority vote adopt a resolution recommending a plan of distribution and directing the submission thereof to a vote at a regular or special meeting of member having voting rights. Each member entitled to vote shall be given a written notice setting forth the purpose, plan of distribution, or a summary thereof, and that the date, time, and place of such meeting within the time and in the time manner provided in this code for the giving of notice of meeting, and such plan of distribution shall be adopted upon approval of at least two-thirds of the member having voting rights present or presented by proxy at such meeting.
Section 95. Definition and applicability of title. A closed corporation, within the meaning of this code, is one whose articles of incorporation provides that, first, all the corporation's issued stock of all classes, exclusive of treasury shares, shall be held of record by not more than a specified number of persons, not exceeding 20. Second, all the issued stock of all classes shall be subject to one or more specified restrictions on transfer permitted by this title. And third, the corporation shall not list in any stock exchange or make any public offering of its stocks of any class. Notwithstanding the foregoing, a corporation shall not be deemed a closed corporation when at least two-thirds of its voting stock or voting rights is owned or controlled by another corporation which is not a closed corporation within the meaning of this code. Section 96. Articles of Incorporation. The Articles of Incorporation of a closed corporation may provide for: first, a classification of shares or rights, the qualifications for owning or holding the same, and restrictions on their transfers, subject to the provisions of the following section. Second, a classification of directors into one or more classes, each of whom may be voted for and elected solely by a particular class of stocks. And third, greater quorum or voting requirements in meeting of stockholders or directors than those provided in this code. Section 97. Validity of restrictions on transfer of shares. Restrictions on the right to transfer shares must appear in the Articles of Incorporation, in the bylaws as well as in the certificate of stock. Otherwise, the same shall not be binding on any purchaser in good faith. Said restrictions shall not be more onerous than granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholder with such reasonable terms, conditions, or period stated. If upon the expiration of said period, the existing stockholders or the corporation fails to exercise the option to purchase, the transferring stockholders may sell their shares to any third person. Section 98. Effects of issuance or transfer of stock in breach of qualifying conditions. First, if a stock of a closed corporation is issued or transferred to any person who is not eligible to be a holder thereof under any provision of the Articles of Incorporation, and if the certificate for such stock conspicuously shows the qualifications of the person entitled to be holder of record thereof, such person is conclusively presumed to have noticed of the fact of the ineligibility to be a stockholder. Second, if the Articles of Incorporation of a closed corporation states the number of persons not exceeding 20 who are entitled to be stockholders of record, and if the certificate for such stock conspicuously states such number, and the issuance or transfer of stock to any person would cause the stock to be held by more than such number of persons, the persons to whom such stock is issued or transferred is conceivably presumed to have notice of this fact. Third, if a stock certificate of a closed corporation conspicuously shows a restriction on transfer of the corporation's stock and the transferee acquires the stock in violation of such restriction, the transferee is conclusively presumed to have notice of the fact that the stock was acquired in violation of the restriction. Fourth, whenever a person to whom stock of a closed corporation has been issued or transferred has or in conclusively presumed under this section to have notice of 1. The person's ineligibility to be a stockholder of the corporation, or 2. That the transfer of stock would cause the stock of the corporation to be held by more than the number of persons permitted under its articles of incorporation, or 3. That the transfer violates a restriction on transfer of stock, and the corporation may, at its option, refuse to register the transfer in the name of the transferee. Fifth, the provisions of subsection shall not be applicable if the transfer of stock, though contrary to subsections A, B, or C, has been consisted to by all the stockholders of the closed corporation, or if the closed corporation has amended its articles of incorporation in accordance with this title. F. The term transfer, as used in this section, is not limited to a transfer for value. G. The provisions of this section shall not impair any right which the transferee may have to either rescind the transfer or recover the stock under any express or implied warranty. Section 99. Agreements by stockholders. Agreements duly signed and executed by and among all stockholders before the formation and organization of a closed corporation shall survive the incorporation and shall continue to be valid and binding between such stockholders. If such be their intent, to the extent that such agreements are consistent with the articles of incorporation, irrespective of where the provisions of such agreements are contained, except those required by this title to be embodied in said articles of incorporation.
Section 100. When a board meeting is unnecessary or improperly held, unless the bylaws provide otherwise, any action taken by the directors of unclosed corporation without a meeting called properly and with due notice shall nevertheless to be deemed valid. Before and after such action is taken, a written consent thereto is signed by the directors. All the stakeholders have actual or implied knowledge of the action and make no prompt objection in writing. The directors are consumed to take information action with the express or implied acquiescence of all the stakeholders. All the directors have expressed or implied knowledge of the action in question, and none of them make a prompt objection in writing. All action with the corporation power to take all the meeting held without proper call or notice is deemed ratified by our directors who failed to attend, unless after having a knowledge thereof the director promptly files his written objection with the necessary of the corporation. Section 101. Preemptive right in closed corporation. The preemptive right of stockholders in closed corporations shall extend to all stock to be issued, including the issuance of the treasury shares, whether of for money properly or personal service in payment of corporation debt, unless the article incorporation provide otherwise. Section 103. Deadlocks. Notwithstanding any contrary provided in the closed corporation articles of the incorporation bylaws or stakeholders agreement, in the directors or stakeholders are so divided on the management of the corporation business and affairs that the votes required for a corporation action cannot be obtained, with the consequence that the business and the affairs of Corporation can no longer be conducted to the advantage of the stakeholders generally. The commission upon the written petition by any stakeholder shall have the power of arbitrate the deputy.
Section 104. Withdrawal of stockholder or dissolution of corporation. In addition, without prejudice to other rights and remedies available under this title, any stockholder of closed corporation may, for any reason, compel the corporation to purchase share held at fair value, which shall not be less than the par or issued value, with the corporation has sufficient assets in its book to cover its debts and liabilities exclusive of capital stock, provide that any stockholder of closed corporation may be, by written petition to the Commission, compel the dissolution of such corporation whenever any acts of the directors, officers, or those in control of corporation is illegal, fraudulent, dishonest, oppressive, or unfair, prejudicial to the corporation or any stockholder, or whenever corporate assets are being misapplied or wasted.
Title 8 Special Corporation Chapter 1 Educational Corporations Section 105 Incorporation Educational corporation shall be governed by special law and by the general provisions of this code.
Section 106 Board of Trustees. Unless the articles of incorporation or bylaws indicate otherwise, the Board of Trustees of incorporated school, colleges, or other institution of learning shall, as soon as they are constituted, classify themselves so that the term of office, one-fifth of their number, expires every year. Trustees elected to replace vacancies before the end of term will only serve for the remainder of the term. Trustees that are elected to replace vacancies created term expiration will serve for a one-year term. For the purpose of conducting business, a majority of the trustees will form a quorum. Trustees' right and authority will be defined by bylaws. The number and term of directors and institutions constituted as stock corporation is determined by stock corporation provision. Chapter 2 Religious Corporation Section 107 Classes of religious corporations. One or more individuals can form a religious company. Corporations, sole, and religious societies are two types of corporation. This chapter, as well as to extent relevant, the general laws on non-stock corporation control religious corporations. Section 108 Corporation Sole. The chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of any religious denomination, sect, or church may establish a corporation sole for the purpose of administrating and managing the affairs, property, and activities of such religious denomination, sect, or church in the capacity of trustee.
Section 109. Articles of Incorporation.
First, that the applicant chief archbishop, bishop, priest, minister, rabbi, or presiding elder is the single representative of the religious denomination, sect, or church that wishes to establish a corporation. Second, that the religious denomination, sect, or church laws, regulations, and disciplines allow for and do not prohibit being sole proprietorship. Third, that the religious denomination, sect, or church affairs estate and properties within the territorial jurisdiction and managed by such chief archbishop, bishop, priest, minister, rabbi, or presiding elder as precisely defined as the Articles of Incorporation. Fourth, the process by which a vacancy in the office of chief archbishop, bishop, priest, minister, minister, rabbi, or presiding elder must be filed in accordance within the religious denomination, sect, or church rules, laws, or discipline. And lastly, the place where the corporation's sole major office is to be created and located, which must be within Philippine territory. Any other provision for the regulation of the corporation affairs that is not contrary to law may be included in the Article of Incorporation. Section 110. Submission of the Articles Incorporation. Articles of Incorporation are to be submitted. The Article of Incorporation must be verified by an affidavit or affirmation of the Chief Archbishop, Priest, Minister, Rabbi, or Presiding Elder as the case may be, and accompanied by a copy of such Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elders certificate of election or letter of appointment duly certified to be correct by any notary public.